All right, please be seated. Steve Mallon and Real Estate Holdings LLC, Norman Zilligan. Tweedle, who do you have?
I have Mallon.
Attorney Reed. Good morning. Who do you have? And Attorney Yanni, you have Sam. Teaming up on Tweedle. What are we doing on this one?
Well, I mean, basically, it's just this is a tax sale matter that went all the way through to order and deed, and I think notices were provided all along to the property owner. Apparently, he had a pending issue passing an assessment on that property, and regardless of the pending assessment, the property was sold for tax sale, but the property owner never paid in the interim any taxes and never entered an appearance or filed an objection to the petition for deed until after the deed was issued. Apparently he did file with the most recent item that I just recently received. It wasn't really an objection. It was kind of titled Verified Motion to Determine Property Rights, and that was filed pro. We never received any notice of it. Subsequently, we had filed a quiet title action, which is pending in Room 1. And prior to filing my motion for default judgment, I found out about this status.
We were before you in February.
Yeah.
It was initiated as opposed to a filing. We set it for today, so it's been a bit of a schedule.
Right.
And it looks as though basically what we have is trial proceeding initiated by the company. We'd like to talk about consolidating the quiet title involved in this court. Got the discovery during the passing of the last time here. A little bit left to do, not much to involve. But we'd like to get some of that discovery done.
Sure. So how much time for discovery?
Well, just through the end of June, so...
Why don't we set discovery cutoff July 31st? And we'll give you, do you want a hearing date then in August, or do you want another pretrial?
I think we should have a hearing date.
Yeah, I think under Trial Rule 42, the motion needs to be filed in the court having when the first filing was made. I guess we would use the tax sale filing in the close. So this would be the court where you'd file the motion to consolidate.
Oh, here it's supposed to be.
Yes, yeah, you file the motion to consolidate in the older action, which I think would be this one, simply because it's keyed off of the initial application for sale by the treasurer. Yeah, it's fine. So discovery cutoff July 31st, 2014. And we'll set it for hearing. That was August 12th. August 21st, 9:30. Anything else we need to address now? All right, very good. You're welcome. And then you have the second. You have Armstrong Family Trust and Norman Zilligan.
We have, I think it's Greenwood International Plan, Armstrong Family Trust, but it is.
Attorney Jones. All right. All right. The file I have indicates the tax sale purchaser as Armstrong Family Trust. At least that's how it was filed by Attorney Lewis. Attorney Yanni, you would have interviewed his Greenwood International team.
That same February hearing that I referenced in the last meeting.
Right.
The Lewis, a letter immediately followed that hearing, closing my appearance. At that time, I didn't think that was
Have you had an opportunity to look at it a little further to see?
It's somewhat similar circumstance that our query right now is how it got through the tax sale as opposed to what happened in the 4.5. The question is whether it's eligible for tax sale in the first place is expiring. And I just, in that vein, I guess, getting records from the auditor's office, I got further records today from the first office, trying to follow.
Essentially the same issue that there was an appeal of the assessment that was pending at the time that was placed on the tax sale.
Previous, it had been pulled from the sale, previous occasion. At least it had been this time as well. We're trying to ascertain what remained on sale, or what it didn't. If it was on sale, why? At least so far.
Well, the issues that would be quiet, but for the remedy, potentially. Okay, I guess the question is this, who's the tax sale purchaser? Does anybody have the certificate? I don't see it in my file.
I have the notice tracked down.
Is Armstrong Family Trust a successor in doing that, or do you have any? This looks like it was as a result of Commissioner salary. So it landed on the first treasurer's salary, then on salary. county, so the tax lien commissioner said. I don't have all the file in front of me, but
Yeah. Part of it is I'm trying to. Together, but I've got enough starting
Piecing
to
the-
go back.
yeah, piecing the pieces that I can see in the file that gets opened when there's an objection, it appears to me that that's likely what happened. Because it went through a treasurer's sale, it wasn't sold. And then it went through the commissioner's sale, at which time it was sold. I don't have the tax certificate in here. I can't tell you what it. All I know is that at the very first documents refer to Greenwood International, and then later yeah, the original. Well, I guess we can sort that out. What are we looking at then? Basically the same track as the other one?
I think so, but maybe a little more time in discovery here. Yeah, that gate.
Well, do you want to set the same discovery cutoff in the same hearing date? But if you're not done, then we'll continue it.
Yeah, that
But that way, if you get done, at least you're on the calendar. It's the same day. You'll be here on both issues. And, that way, you won't have to come on 2 separate days. With it being in mind, if you're not ready, you're not ready. Then you'll just kick it out a couple months or anything. All right, discovery cutoff, at least at this point in time. Try and endeavor to get it done by July 31st. If you can't, then we'll go from there. Hearing is set for August 21st, 2014 at 9:30. Again, if you're ready, we'll do it that day. If not, you know. Yep. Okay. Barbara Hacker, American Service Insurance Company, 45C01, PL 123. Attorney Sursik is here on behalf of the plaintiff. Oh, and for the treasurer, on behalf of the defendant. Good morning. What can you tell me about this one?
This one is a underinsured motorist case. We got through the plaintiff's deposition. I think just 2 things. We've been trying to set the 30B6 deposition. ASI, just due to scheduling problems, haven't been able to do it. I think we're ready to get a trial date. I just
Does this case lend itself to mediation?
Well, it's a difficult question. I put it this way. I think that ASI is in compliance that this is not a policy limits case. I think my client is in compliance that it is. Whether or not there could be some reasonable common ground between those two is a debatable question for mediation. I wouldn't be adverse to going to a mediation. On the other hand, I don't know, that's a long-winded answer to the question.
So, how many they filed?
I would say,
How about the week of February 9th, 2015?
I have a primary certified date, June 7. You know, who knows, and if that settles in the last minute, I think I have work.
April 13th.
I am
All right, April 15th, and keep Discovery open until the end of the year.
that would be
Discovery open until December 31st. We can open. There will be some dates backing up off the primary, but then the other two will be the six months. Order setting. All right. 3 days.
I have another dates.
Yep. Stay seated. Which one is it? Don't move. Which one is it?
Warrants,
Yes.
and that is set for mediation.
Okay, hold on one second. William Torrance versus Robert Fuller, 45 C 126 CQ 124, attorney Cercius Governor 2024. With that, is that a mediation set?
Yeah, set for May 20th, and, you know, who knows, it could get done, not get done. I would say, either the trial date now, or come back to the trial date.
We'll give you a meeting status. 10:30. June 10th, 10:30.
At
10:30.
10:30, I can do that.
All right. See you then. Good one. All right. Are you here on Walsh?
Got two others, yeah. Walsh and
Walsh versus Chapman. 45 CO1 1301 CT4 Anita Walsh. Moved by Attorney Wilson. Attorney Treasurer's on behalf of both defendants. And it looks like there was a mediation. Attorney Wilson apparently wanted too much money.
I'm just covering for Duke.
Duke wanted too much money. A mediation report says parties were unable to reach a settlement. Any hope of that, the position's changing?
My guess at this stage would be that it's not probable if we could get done in mediation. We could just get trial dates. Trial dates have a funny way of motivating people, one side or the other.
Indeed.
I don't have Duke's full calendar. Their report later.
February 9th. I know you had said that you had some others on this Sean's.
Oh, no, it's on both.
Oh,
There's two set that week.
okay.
Right.
June 1st, 2015. All right.
Judge, if memory serves, that's the 1 week that Duke cannot. I know if you know Duke, he has a tendency to get very histrionic. And last year I set one in June and I thought he was going to pass out.
So you're saying the entire month of June?
I think it's the first 2 weeks of June. My apologies.
How does he feel about August?
It feels good now.
Was okay with August? August 10th? 2015.
And my understanding from Duke,
Discovery
Your
until
Honor,
the end of the year, or the understanding is what?
well, from Duke and having watched him in trial, when he compared to Dawson, that would be a 3-day. Your Honor said discovery till the end of the year,
Yes.
12/31.
And you'll get dates backing up off of that for the other case management issues that we're exchanging in terms of witnesses and exhibits, filing a pretrial order, filing motions and amendments. Anything else?
No, sir.
Yep. All right. Rosa Roman versus Mark Henderson.
That would be us as well.
County Treasurer on behalf of the defendant. Wilson as the plaintiff. It appears that there was a mediation scheduled in March. I don't have a report. Did that go or did not go? Okay, so you need to reschedule mediation.
Correct. I believe actually we're supposed to discovery in this particular case. We're trying to find out specifically they've answered discovery, their written discovery, but we need to find out what their actual inquiries were because of that. So that's the only thing I'm waiting to get an answer on. Everything is that I think that's
So how much time for additional discovery and getting the mediation?
I'd like to
Even with attorney expertise and urgent to work.
Oh yeah, I forgot about that.
I don't know if I limited the aversion.
My gut says, Your Honor, just with our schedule and generally the practice, where our appetites for speediness tend to be bigger than they are. We could show 90 to 120. Because when we're talking about also a mediation, now we're at the delivery of a mediated schedule. I don't think we stipulate which rule, but
Galen Bradley.
We've got to get it.
yeah, he can get us in 120. 90 starts pressing. I know I had
So
some
we're
issues.
looking at, let's see,
So 120 August.
mediate it, do your initial discovery and mediate it by August 31st, 2015. I'm sorry, 14. Not that slow. Look at that 15 calendar. August 29th. I'm sorry, that's a Friday. And we need a date in September. Let's see.
And I'll make a note for Duke's secretary to contact Mr. Bradley's office because if we wait, then we'll end up having to extend mediation dates. We can get something on the book.
Yeah, September 17th. Because the judicial conference. September 17th at 9:30. Right, you gentlemen take up another course. You're welcome. I see Attorney Eskew's name on another file. I don't know if he's Mildred Henry. Henare. Mildred Henare and Munster Med End. All right. Attorney Wilson, you have
The plaintiff, Your Honor?
it's 45 CO1, 943, 16, you have the defendant. Where are we on this one? Okay. Yeah, I had some extensive notes. Apparently, at some point in time, I had looked at this.
Probably be set.
September 17th at 9:30. Other status. You're welcome.
Thank you, Your Honor.
Donald Briney versus Guru Marketing Group et al. Attorney Novak has the plaintiff. It's 45 CO1, 1109 CT 133. Attorney Bentley. It's here on behalf of the defendant. Apparently there's been a mediation to no avail.
Correct. We're still talking, but didn't settle that.
What's your pleasure? Any comment?
Probably.
February 6th, 2015. I'm sorry, it should have been February 9th. It is. You're early. Let's see. What did I get? June 1st? Yeah. Discovery till end of the year, December 1st, 14, and we'll back up the exchange of witnesses, exhibits, pre-trial order filing, motions to adjournment, order second. How many days?
3.
3 days. All right, very good. You're welcome. Pekin Insurance Group versus American General Builders LLC. 45 CO1, 1210 CC 144. You are Attorney Nelson for the plaintiffs. Mr. Ivanovich is here self-represented, set for status. This is your first time hearing this.
Yes.
The representations, at least in the court, and I don't know if you've had an opportunity to look into it any further. But the representations have been all along that the LLC is dissolved and has no assets. Is that correct?
Yes, sir, Your Honor. As a matter of fact, I served
So I don't know if that,
I've served
if you've looked into that, or if that's,
My client was recently
maybe by responding. I mean, by dispositive motion, and there's no response to the answer. It's contemplated on the file. Are they by way of dispositive motion? Then we can set a dispositive motion, cut off date, and then move status. I guess in the meantime, I would suggest that whoever's driving the ship, get with Mr. Ivanovich, or at least look into whether or not the debt was with the LLC. The LLC is now dissolved and has no assets. I'm not sure that the folks want to keep sending somebody here. That's truly the case. I mean, obviously, I'm not telling you what the individual case, but if that is in fact the case, that might be something you want to factor in your decision going forward. But, okay. And I don't know if that's true or not. I'm just saying that that's what the representations have been along the way. There's been quite a history of the case as far as there was a default judgment entered. There was a hearing on whether to set that aside. That was then set aside by the court. The court then granted leave for Mr. Ivanovich to file an answer, which he did. Now that the issues are closed, we can proceed to a normal case management course of discovery with a bench trial or dispositive motions. I guess, based upon my understanding of the case, I just would encourage you to look further behind that and see if it's something that it's worth pursuing. But in the interim, I will set a dispositive motion deadline of July 31st, 2014. Initial discovery cutoff August 29, 2014. Further status September 17, 2014 at 9:30.
Your Honor, I'd like to address a couple of issues here that you brought up. One, the debt is solely American General Builders, according to the policy. We didn't sign it. I didn't sign off on it personally. The debt was for American General Builders, and there is no signature of a person here. So, however, the court has to review that. Furthermore, I sent registered letters according to previous conversations in court to Mr. Scott Martin, who's the CEO, and his chief financial officer back in January of this past year with no response.
specifically telling them, for lack of, without going through the whole letter, basically telling them that, you know, that the company has no assets, it has no bank accounts, it has no money, it doesn't exist anymore. So I don't know what they're trying to get. Furthermore, that it was based on audit of sorts that were incorrect. Neither here nor there. There's no assets in the company, as been stated.
Well, that's what I indicated. But today, we're not here on a hearing on the merits to dispose of the case. It's simply a status conference where we've set some deadlines and done that. So the two of you can just.
There's been numerous attorneys in this case. I mean, there's five.
That's why I
Number
indicated
five.
that he may want to. Now, did you enter an appearance, or are you with the firm of Blitt?
I was retained.
So the order of the case range order today should go to Mike Starzik.
Should, Your Honor, July 31st for
Dispositive motions.
August 20th.
Yes.
Status.
Yes. You're welcome.
Thank you, Your Honor.
Yep. Scott Kubis versus Jim Simonowski. Morning. Plaintiffs have withdrawn. Plaintiffs' counsel. 45 CO 150 C 259. Attorney Swachka you have the defendant? Okay. And then let's see. You were going to find, or try to find, Scott Kubis.
Apparently what happened, was charged, Turkey, sort of last week. The interim attorney, Alvarez was charged with finance. They're working on order number 3. No one's showing up the second time.
Do you have an address for Mr. Kubis? There's one on the withdrawal letter of 2501 Central Avenue in Gary, 16407. So what's are you intending to file a motion to dismiss pursuant to 41E? Do you want a hearing date on that? And you can file that. That way you can put the hearing date on your. June 11th, 1:30. Or would you prefer 9:30? On June 11th? Is it a bench trial or is it a motion for summary judgment? Oh, okay. Well, did you want to do it in the morning on June 11th? Well, I just wondered if you wanted to piggyback it on conflict, come in 11:30, and since you're going to be up there anyway. No? Okay. What about just the day before? Are you going to be preparing for the bench trial? June 10th? No, I'm sorry, the day before your bench trial, are you going to be preparing for the bench trial? At 11:30? So we'll set it for hearing on 41E. You'll have to file that motion along with the CCS going ahead and setting it for hearing and getting Mr. Cubis served with that motion. Certainly make sure of your motion and your request that you're asking to be dismissed clearly so he knows. June 10th at 11:30. All right, very good. Irene Kleinis versus Alyssa Manzo. This is the last 9:30. All right. Irene Kleinis and Alyssa Manzo.
Your Katie Mara, notes. May I approach?
Sure. Do you have a clearances?
Yes, Your Honor.
Attorney Mara, M-A-R-R-A, appears on behalf of state defendants, State of Indiana and State Department of Transportation. I see that Knight appeared on behalf of Alyssa Manzo yesterday. Attorney Keith, care to jump in the fray here? This is a case from your office. Irene Kleinis, one of Mr. Cullen's cases.
Yeah.
Right. Let's see. Attorney Pyle appeared at the last. And Cullen's entered. And it appears that one of the other defendants just switched counsel, or maybe they didn't pick up on the hearing date. I don't see a motion to continue. But from the thickness of the file, it appears that we probably all just conducted discovery anyway. Can you give me a status?
Recent discovery, state of recent discovery.
So it sounds like we need a case management order just to get the ball rolling.
That would be
All right, well, why don't you conduct your initial round of discovery and do that by the end of August 29th, 2014. Come back September 17th at 9:30. And we can determine what additional discoveries needed, whether or not there's going to be a Tribal 35 medical exam, whether or not litigation would be viable in this case, the ability to respond to motions. Okay.
I will read it.
All right.
I
Very
have
good.
August 29th, 24th, we get first round instructor group, September 17th at 9:30.
Next steps. Yeah. And we'll reevaluate where you're at. Figure out where we need. You're welcome. Sorry for your wait. Yeah, stuck at the end of the call.
No problem.
All right. Are there any 1030s checked in? Ready to go? Whitviat versus Pinnacle. 45 CO1, 1312 PL 119. Attorney Cunningham is here on behalf of the plaintiff. Attorney Kenyon for the defendant. I owe you guys an order. Sit on my desk. I think I'll get it out soon. Where are we otherwise?
Your Honor, the discovery that we were waiting for after our hearing, to arrive, timely, and the depositions that were subject lo and behold, they said, and I've been assured by counsel, there's no objection to our things until I. So right now, I think the case is back on a normal course, so
How much time for the first round of discovery?
I think we only need, both of them, 2 months. That's some time.
Okay. August 29th, 2014. Further status, September 17th at 9:30. At which time, hopefully, we'll know if there needs to be a trial. Is this a case that lends itself to mediation? Based upon your comments at the last hearing, it didn't sound like it.
And there's experience counsel on both sides.
Fair enough. I don't like putting added layers of expense behind cases.
Once the earliest time we could actually do the court date.
You mean a trial date? It just depends. I mean, usually we want to make sure that all the initial discovery is done and the parties have exhausted all avenues of trying to get settled, whether it be discussions between counsel after having conducted your discovery or mediation. We don't like to get the trial dates out if people are still in the process of trying to get it settled. We don't set them pending like some other courts. We go to primary and it is what it is. So if we gave everybody trial dates a little sooner than normal, a little sooner than some other courts may do, then we would have. So we try and work a balance between doing the 10 settings and you don't find out until Friday before one day.
I might have to sort of generally what's the calendar like? What dates are generally?
I was off. I've been offering dates early next year, and a lot of them weren't even thinking they wanted them later. So usually run about 8 to 12 months out. We haven't had a problem getting things in 2 years. And is this a jury trial? I assume. Let's say if it's a bench trial, we'll do it. Attorney Burkett and Attorney Rake, just the two of you, right? Or am I leaving someone out? Yes? Okay, Eric Alcantara versus City of Hammond. Attorney Rake appears for the City of Hammond. Attorney Burkett for the plaintiff. 45 CO1, 1007 PL 132 were set for status. I think we had a trial setting. There was a motion to continue and an objection there too. The court considered both and granted it. So do we need to just reset the trial? Is that what we need to do?
Well, we had another motion, I guess, have to consider whether or not they have to do the bond, whether or not they can set the time, which is going to be the rule.
Had responded to that agreement condemnation, but as I'm sure you're well aware, the fact that we have appealed this matter does stay in hand on the FD property.
We understand that. On the other hand, we have the burden going forward. Right now, we've gone 4 years and we're continuing to have this facility without any consequences. In any event, I guess that's the problem with the two. We are, I'd say, file. I don't know how long the file is. Bring the no-go in fashion on it, but
Well, yeah, it's this isn't a jury trial. No, my statement was that the jury trials are running 8 to 12 months out, and I think I followed that up with bench trials are running 30. So
30 days.
30 to 60, depending on. A lot of times they run further than that, not because of our calendar, but because of council.
And we have no problem with the 30-day time frame. We're ready to proceed really,
This is a review of administrative order,
Yes, Your
correct?
Honor.
Yeah. Okay.
I mean,
So there won't be any new evidence, correct?
no, we have given them everything that we have because provided.
I mean, this is strictly a review of the administrative record. Is this strictly a review of the administrative record?
Technically, the court could hear this.
Is there going to be additional evidence?
Basically, I know that their summary judgment motion was withdrawn, but in broad strokes, everything that was contained as an exhibit in our response to their summary judgment motion, as well as testimony.
The question, Your Honor, would be whether you want to do this.
I would say probably yes.
So that's why we're
And trying to, are you, do we need a hearing on the posting the bond, or if we get you in here in 30 to 60 days, does that make a difference? Okay. So if we get you there in 30 to 60 days, you don't need that?
yes.
Okay.
I just don't want anything to happen.
I understand. Yeah.
Pending, so
How long of a hearing are we going to do?
well, we were set out originally.
Let me look and see what we were
We
set
have two.
for.
We went from no hearing on any witness to now 2 days.
Well, we had set out the matter originally. The trial
We
that
have
was
one
taking
witness.
place.
All right, let's see. Bench trial set for 2 days. remind me why we were sending it to you guys.
We will be having testimony from Eric Alcar, building owner, as well as testimony from prior. We have a number of documents.
Have you all exchanged your list of witnesses and exhibits? With regard to the exhibits, not holding either one of you two at this point, in order to kind of get a grip of what we're dealing with as far as that goes. Do you anticipate any objection to any of those?
I don't think in a particular sense. However, substantively, we do not do permitted development.
You? Any objection to any of theirs?
Well, I think.
I guess I'm trying to determine whether or not we need a final pretrial conference from them, and I don't like to go
Right,
through hearings where it's objection to everything, objection.
Here's my lay of the land. My perspective is, we have to do information to testify. Their essential defense is a single thing as well that the part of time somehow that grandfather instills water department or the party allowed to have years to somehow allow to have it.
So do we anticipate lots and lots of objections that we would make final pretrial conference to address?
Our side having related to testimony or where we have more perspective.
Well, it sounds to me like we can get better today.
I don't know. I think that was one tight.
What can they possibly testify to other than, what is the testimony going to encompass other than, if you're talking about a structure and, I'm having a hard time anticipating how somebody could be on the stand for 3 hours.
I just want to say we may end earlier than 2 days, but I would foresee it going into the next day a little bit, maybe for a couple hours to get out process. I believe with a deposition of building commissioner at that time, I believe we had a brother deposition. That may end up being the case.
I have a copy of that here.
I know that drew a lot of objections.
Hour deposition.
We can characterize it in two different ways. I still think it's narrow-ish question today. All I'm trying to do is
Right, I understand. May 19th? Yes. Do you have May 20th? June 2nd, it's a Monday. Set it for one day. If we don't finish, I think we'll be able to spread it the next week. Roberta Wilson and Doris Wilson versus Amanda Linenberger, 45 CO1 1305 CT 70. Attorney Werner, you have the plaintiff? Defendant.
Yeah.
And Attorney Rupsich, you have both plaintiffs?
Yes.
You do an initial discovery?
Yeah, Judge, this is a pretty straightforward process. Discovery. Unfortunately, those terms.
All right. Can you complete your discovery by August 29th? New status September 17th at 9:30. Yep. August 29th, 2014. Anything else?
We'll set the trial dates then on the next Saturday.
Well, without having a crystal ball, it just depends on where you're at. But I mean, if you've got all your stuff lined up, then you'll set a trial. Yeah. Yep. All right. Allstate Insurance versus Gilbert Benema, 45 CO1 1006 CT 108. Attorney Grant is here on behalf of Allstate. Attorney Werner on behalf of Gilbert Benema. Where are we? Back to square one.
Yes, Judge, to bring the court up to speed, the court set aside plaintiff's summary judgment. No estate has been opened for the deceased defendant, and as I advised the court, firm's intention is to file a petition for the appointment of a special administrator lawsuit. have a petition prepared, and I don't know if we're supposed to do it today or I can do it. Then especially in terms of appointing and moving forward. Once that's done, I don't expect to discover it, but obviously I'm not going to negotiate on it. And plenty of those, excuse me, demonstrate deposition, making sure that once we get special answer,
well, I could, but the easiest way to do it is simply go down to the clerk's office and file it, and they'll send it up tomorrow to the public commissioner, because you don't actually need face-to-face court time. You can look at the file. It's a straightforward opening of an estate for the purposes of
sole purpose of appointing special answer.
right. Yeah, just go down and file in the clerk's office. It'll be set up and dealt with tomorrow by Commissioner Harris. So what do we need? Just a new status date?
If we could set it out,
New status September 17th. That week?
Either end of August or
Yeah, we don't do them telephonically because, as you see, we have a courtroom full of people, and I tried to do that for a while because I am an accommodating judge and a nice guy. However, this becomes too disruptive to try and get on the phone and off the phone, and people aren't available, and it just doesn't work. So.
I fully understand.
August 20th. 10:30. All right. You're welcome. Yep. Marriage of Wood. 45 CO1, 1204, DR 342. Attorney Keith appears on behalf of Cheryl Wood. Attorney Nichols is here on behalf of Mr. Wood. We've got an outstanding petition to modify filed by Mr. Wood to modify child support.
I think it's likely that this is going to be a small drama because it's just going to be an agreed modification that we're going to review. And as he said, our client's income hasn't changed to date from the date of final decree, which was the end of 2012. So we were just waiting on an agreed modification.
Okay, how about I do this? How about I continue it generally to be reset at the request of either party for the negotiations? I like yours. Okay.
Absolutely, Your Honor.
All right. Yeah, if it sounds like you're going to get it done, then we'll just continue generally to be reset if needed.
Okay. Thank you, Your Honor.
Yep.